Hearing in the appeal of SkyKick UK Ltd and another against Sky Ltd and others.
Mr. Speck, before you begin your submissions, can I just ask, is this a case in which the parties are having a transcript of the hearing prepared? Fine.
Yes.
Yes. Well, that's helpful for us to know, so we needn't take quite as careful a notice. We can sit and we can actually listen to you rather than trying to write it all down.
Can I just double check that? I answered yes with complete confidence. Yes, somewhere in the building, not far from here, is a shorthand item.
Fine, thank you. Yes, Mr. Speck.
My Lords, can I start with an overview before I give my Lords a route map of where I want to go with the development of the rest of my submissions? Registered trademarks have been around for about 150 years. And what a registered trademark system is a development in the law that offers traders the ability to have registered trademarks, to register as trademarks, the signs that they use that enable consumers to distinguish those goods of the trademark owner from goods or services of a different origin. And it's a benefit to society generally because it offers an efficient scheme that traders can utilise, which contributes to a system of undistorted competition. It's also of benefit to individual traders because they can firstly secure exclusive rights in the signs that they use to signify to consumers that goods or services originate from them and not others. Secondly, they can efficiently enforce those rights. And thirdly, they can consult the register to see what signs may be free for them, both for possible usage in the marketplace and for their own application for protection and entry on the registry. So, my Lords, the interests in play in such a scheme are not just the existing trademark users, but those of the future too. The ability to secure a mark in the future is important as the ability to enforce the marks already registered. And the register needs to be something where it's not overly burdensome to find space as a new trader. Now, my Lords, trademarks are, as I say, all about signifying to consumers the origin of the goods and services in respect of which they're used, and that is why the cases refer to that as the essential function of the trademark. My friend tries to broaden that out in his printed case by referring to things like the so-called investment function. It's a rather clumsy phrase that's been coined to specifically focus on the attractive pull that a trademark with a reputation may possess. But there's a reason that the function of acting as an indicator of origin is the essential function, because everything is in reality just a further facet of and dependent upon the essential function of signifying origin of goods and services. And in this case, the underlying cause of the parties' diverging positions, and indeed the striking difference between the Court of Appeal and the trial judge, initially Mr. Justice and then Lord Justice Arnold, is really this. It's a difference in view as to whether trademarks ought to be available to be registered only where and only to the extent that the applicant's purpose in applying for the monopoly conferred by the registration is use in accordance with that essential function. In other words, are trademark schemes pursuant to which trademark monopolies can be acquired from the state, or in the case of European marks from the EU, available to be used by the public to acquire exclusive rights only for the purpose I've identified, or can individual traders, applicants, have other purposes, in fact any purpose they like? A trademark is, after all, a monopoly made available by the state that any person can, in practice, acquire simply by following the rules in filling out the form, paying the fee, following whatever express rules there may be, for instance, as to the width of the term or goods and services you include. The fundamental point between us is this: is everything fair game if those fees are paid, the forms are filled in, and other specific express rules followed? Or must the scheme be being used for the purpose for which we say it's intended and no further? That is the key issue that underlines the main dispute between us. And the specific illegitimate purpose, or abuse, if you will, in this case, is that of securing monopolies with very broad protection, regardless of whether commercially justified, simply to use as a legal weapon to deploy against others. That use as a legal weapon is both use in terms of disrupting activities in the marketplace, so going after people who have begun using marks in the marketplace, but also disrupting others' ability to secure their own registrations, so blocking them in oppositions. And Sky is not shy about that activity. It was open in explaining its programme of trademark enforcement. And at this point, I just draw a parallel. It's rather like Hasbro in the Monopoly case that you may have seen. They were doing something different, but it was a party who frankly explained its strategy in that case. And in that case, it was to avoid the trouble and aggravation that the trademark scheme requires of trademark owners if proving use of marks over 5 years old. And they simply used the rules by applying for a new one. But they were completely frank about it. Monopoly was another case of conduct in strict compliance with the rules, perfectly candid trademark applicant, but it was using the scheme other than in the way it was intended, so the applications were made in bad faith. And I say Sky's intention was to secure a right to use simply as a legal weapon. I think the judge used the word purely. And by that, of course, trademarks are monopolies, restrictions on trade, and to that extent they are, of course, legal weapons anyway. Legitimately, they are legal weapons. But when I say simply, or the judge says purely, the point is that I'm trying to make, and the judge was making, is where you've registered for goods or services where the registration is not accompanied by and protecting the proprietor's own use in accordance with the essential function, the registration is divorced from that essential functional purpose. So the only purpose is to be using it to bang other traders over the head with. And that's what I mean when I talk about simply, or the judge said purely.
Well, Mr. Speck, certainly for my part, that may be rather overstating the case that you have to meet, because as I understand it, one of the important points made here by the respondents is that when one applies for a trademark in respect of a putative business, there may be more flexibility in the permissibility of making an application for a trademark in relation to goods or services, where first of all the intended proprietor is not actually using it in relation to those goods or services at the date of application, but secondly, there may be no guarantee or indeed certainty as to the nature of the business or services which will ultimately be used. So I'm sure you're going to come to that, but in addressing us in your opening remarks, it may be important not to overstate the nature of your case.
Certainly. What my Lord's really raising is how certain do you need to be when we talk about having an intention to use?
At the date of application.
At the date of application. To be absolutely clear, we are talking about the date of application as the test here always. And the point that my Lord has raised is an important one, in that there's definitely cases, and we'll see it mentioned, where it's said that you don't have to know precisely what you're going to do. So things may pan out differently, and there may be issues as to just how firm ought your intention to be. So you may have an intention that if things go well, I'm going to use it for X after Y. And I totally accept that. In this case, there is no detail like that as to, well, we intended this if particular things had panned out. So my Lord's absolutely right.
You'll no doubt come to that, but as a matter of principle,
certainly
at the moment.
Well, let me put it this way, my Lord. What I'm really talking about is the to whatever extent intention to use captures the kind of things that my Lord is talking about, that is obviously fine. There may be a dispute, or in a particular case you may argue about what that is. But my friend's case is that you don't have to have any of that kind of intention at all. My friend's case is that you can have goods and services where you just don't have that. And that kind of stark case, and that stark dispute between us is what I'm trying to identify as the underlying dispute.
Certainly, a second point, so far as these initial remarks are concerned, that I would be grateful for your assistance on in due course is this. What is the degree of specificity with which one must describe the goods or services for which you have that putative intention that you're going to develop your submissions in relation to? So that seems to me to be another potential area where you may face a kickback, so to speak, against your initial broad submissions.
Can I answer that now? Because it must depend on what your actual intention is. It must depend on that. So there can't be an answer that is always the right answer.
Objectively interpreted?
Yes, objectively interpreted, but you still always have to be looking at what the subjective intentional plans were. And at that stage, I'm going to get into what the right procedure is and how somebody in my friend's position ought to actually come along and tell us.
That's another point again,
that is
a principle. But
what I'm really trying to say to my lord in answer is, it can't be there is one answer as to the level of specificity that applies to everybody if different people had different scope of plans. So you could have somebody that, for instance, is setting up a small software house that only intends to focus on a particular area. And it may be that the right answer in that case is software with the function of the area they intend to focus on. It may be somebody else is going out to the marketplace to get finance and is setting up a much bigger business that they have concrete plans for it to be much broader, and so that they may be able to claim software in a broader way, still limited to particular areas, not absolutely everything. But what I'm trying to illustrate to my lord in answer to the question is that it will depend on the facts and on the particular purpose for which they are actually intending to use the mark.
Thank you.
Can I just ask, in relation to your overview, so I think the picture you're setting up is of a dichotomy between the approach that says it's all has to be geared to the purpose of using. Now, we may have arguments about how one works that out in relation to putative businesses and so on, but that's the underlying idea.
Yeah.
Then I think you contrasted that with, on the other side, the purpose or intention being purely to use as a legal weapon.
Yeah.
Now, I suppose what I'm asking just at this initial stage is that the only contrast? I mean, could there not be other purposes that we might have to examine?
Well, in other cases, my lord's absolutely right. And for instance, there are cases where, certainly the Hasbro case, the Monopoly case, where they did intend to use, and what they were really doing, so they would have been able to prove the use of the older mark, but what they were really trying to do there was just circumvent the rules on having to prove use. So there is it's absolutely right that bad faith is broader. And what I'm focusing on with the use of purely as a legal weapon is this particular circumstance where that is the purpose, which is the abuse. But to be absolutely clear to my lord, my submission is that there is not a closed category of abuses, and if you're not using the system in the way in which it's set up, your application is liable to be held to be made in bad faith. And I'm focusing...
But you say on these facts, it is one or the other.
This particular type where you're applying more broadly for goods and services, it's a form of defensive registration, and I'm going to come on and explain what they are. But for this particular type, the reason that you're applying more broadly than the use that you intend to put the mark to is to be able to do that either in the marketplace or in the registry.
Yeah.
Using it purely as a legal weapon.
I was just thinking that somebody might just have a purpose, that they just want to play safe. They're not actually intending to use it as a legal weapon against other parties, but that they are concerned that if they tie it down too much, even to what they see as the putative business, they may just find themselves caught by the fact that things develop in a way that they might not otherwise expect. But does that fall within, would that sort of motive fall within your initial category?
If what they're doing...
Overcautious person,
well,
I'd say.
But probably they're being overcautious because they want to stop other people in the area they're applying for. So if that's part of what they're doing, that it is illegitimate, my lord. If what they're doing is applying for something, playing safe in the sense of, I'm going to keep everybody off this patch just in case my business develops like Virgin. That is part of what I'm talking about, if that's the way they're doing it.
But they might be cautious in the sense of not appreciating at the outset the way in which, or the areas into which the business may develop.
Yes, and that's really getting into the point that my Lord Kitchen raised with me, is to what extent must they intend or foresee that that's the way they're going. And that really is a situation where what would happen then is that they would be expected to come along and explain and say, look, we had absolutely firm plans to do X, Y, and Z. If that went well, we could see the way the market was going that we had pretty firm plans to do A, B, and C, and we could see that possibly J and H were likely. But
which of those would be bad faith?
Well, there will come a point, my lord, where it is simply, or basically saying a business could expand anywhere. There will come a point where you have to draw a line as to...
Well, I think one of the things we're going to be asked to consider is where should that line be drawn?
Well, on the facts of this case, it doesn't really arise, because what hasn't happened is that kind of explanation hasn't been put forward. And we mentioned in our printed case that there may be cases where the degree of firmness of an intention may be subject of argument as to whether that's good enough. There may be cases.
Insofar as we're seeking to identify a principle here that can be applied both in this case and more broadly, what is that principle, and how should the registry, the tribunal, and all of the other judges who are going to be faced with this question approach it? I'm not necessarily seeking an answer now, but in the course of your submissions, I, for my part, would be grateful for your assistance on that.
I will address it, my lord. I will address it. Can I just carry on with my overview, because there's a risk of me being dragged into the detail where I'm just trying to give my lords a picture of what's in issue. This case also raises issues of how one deals with individual terms in a specification where there is bad faith of the kind I'm talking about, but where a party in the applicant's position acting without bad faith may have been able to secure registration of a narrower specification within that broader term. Does the court always proceed to strive to leave the applicant with the maximum that a party acting in good faith might have secured? If so, that will do little to discourage future abusive applications, which regrettably are becoming more common, because the applicant will make business decisions knowing he's unlikely ever to be pulled up. But even if he is, the worst that can happen is he could get what he might have asked for anyway. One approach. Does the court look at all the circumstances in the case, including the particular conduct of the applicant, how repeated and egregious it is, and do what's fair in all the circumstances? And a fairness test is one that applies in cases of non-use, where there's no abuse at all. My lords will have seen we suggest a fairness test is applicable in cases of overbroad terms, and that will give the flexibility to accommodate the range of scenarios that may arise with differing degrees of culpability. My lords will also need to consider whether it makes a difference that the trademark owner doesn't engage in any attempt to put forward a cut-down term as a fallback position. They don't engage and say what kind of scope of the specification it ought to be left with, instead of simply deleting the terms affected by bad faith. So my lords will have to consider whether doing that affects cases. My lords will have seen that rather boldly, although it has to be said successfully in the court below, my friend says it's an injustice to his client when he doesn't engage in any such exercise, even assuming there's bad faith, unless somebody else comes along, don't think it matters whether it's me or the court, and proposes a cut down with an explanation so that he can address it. That's, as I understand it, his position. He says it's not incumbent on Sky to do anything at all where there are broad terms affected by bad faith. Sky should simply keep the terms framed over broadly that have been applied for and secured pursuant to the strategy we've been talking about, unless somebody else proposes how they might be saved. It really is that stark, that part of his case, my lords. If that wasn't enough, the case also requires, my lords, to consider whether you should roll your sleeves up and engage in a fresh assessment of alleged infringement under what we've been calling Type B. That's confusion infringement, but the limit of involving similarity of both goods and mark, and even Type C infringement. And the final piece of the jigsaw is there's even a Brexit point that hasn't been addressed in the judgments of any of the courts below. And just to outline what arises in that point, you'll have seen that the proceedings were commenced in the first half of 2016, so before the Brexit referendum at all, and they relate to both European trademarks and, in one case, a national registration. So far as the European registration is concerned, it's my contention that the proceedings are pending proceedings in that they were before the UK court on IP completion date. And so the provisions of the Schedule of the Trademarks Act, which deal with that and provide for the court to continue to have jurisdiction as if the UK was still a member state, that obviously involves applying European jurisprudence, because the court remains an EU trademark court for pending proceedings. And we say the same law and approach is applicable as regards the UK registration, and indeed the UK-only registrations that have come into existence on Brexit as equivalents. And to be clear, just to address a point that my friend raises in his printed case, we're not making any submission that any EU case law is not retained case law, as my friend seemed to be worried about in paras 5 to 10 of his printed case. On the contrary, our case relies upon the European cases.
Are they binding on us?
Well, there's one that is afterwards, so might not strictly be for the application of national law, but because you're applying European law, you're a European trademark court for the EU registrations, it is. So, and I'm not making any distinction between...
Well, certainly for my part, again, when you come to it, I'd welcome your assistance on why we're a European trademark court and not dealing with this matter as what is now effectively a UK trademark, which has inherited all the qualities of the European trademark vis-à-vis the UK.
Just to be absolutely clear, you're dealing with that as well, but you're still dealing with the pending proceedings that were before the court where it's a European registration. So we'll see the transitional provisions, but it basically provides for pending proceedings, carries on as if we were still in.
But I mean, this is something we have to address in any event, isn't it? We need to know what is the applicable law in relation to which trademark and which set of proceedings we're concerned with.
Strictly that's true, but certainly my position, and as I understand my friend's complaint, his position is that it's all applicable, all of the European jurisprudence is applicable. But there is a point about the later case
Actually, if there's agreement between you, it's a shame you haven't expressed it. But certainly, for my part, I would welcome concise submissions on what is the applicable law in relation to which particular
I
trademark.
will talk to my friend because I think there is agreement. And I think what I'm doing is explaining that we're not taking the point that I thought he was worried about.
I see.
But I will check with him that there is agreement. Now, can I just make a couple of overview points about my friend's case? It's particularly notable that his printed case contains almost no analysis of Sir Christopher Freud's judgment or his application of the European cases like Lint and Cotton to this case, nor even a focus on the aspects of it where we've called out errors, with one exception, and that's the point where he says that dishonesty is required for passing off, but for bad faith. So apart from that, it's notable that there's very little engagement with that judgment, and what we do see is significant reliance upon a first instance decision of the cancellation division of OHIM, so a first instance decision of the precursor to the Trademark Office from March 2000. So before any of the cases where the European Court opined on this issue, it's the Trillium case, a case not referred to anywhere in Sir Christopher Freud's judgment, yet it's a central plank of my friend's printed case. And just so that my lords understand what I say about that, things have actually developed since 2000 in a quite different way in the European cases. Quite different. So going back to a first instance trademark registry case, it is not really helping my friend at all. We also see what we perceive to be 4 strands or themes of argument in my friend's case. Can I identify what they are? First, we see my friend relying upon cases or a practice note approving that some broad term is capable of being registered. I'll come to the detail of it when we explain the basics of the way the system works, but there is a separate consideration in trademark law, sometimes referred to as the IP translator point, as to whether particular terms can ever be appropriate to be registered as a trademark specification. So whether it's ever permissible, however broad your intention. So these are cases that are focused on the breadth of the term, and some fall foul of this rule, so that no applicant should ever, in any circumstances, be permitted to include such a term. And what my friend does is muddle up what one might call the IP translator point with the bad faith issue. IP translator is concerned with the mark itself, not the applicant's intentional purpose. As I say, whether it's too broad. They're simply looking at whether it should ever be permissible, assuming the applicant's intention is in accordance with the proposed function of the trademark. And it's wrong to say because it's not absolutely forbidden, that means in all cases it's permitted. But that's the thrust of what he's doing. He's saying, look, the term's okay, therefore I must be allowed to have it. And that avoids looking at what we're actually supposed to be looking at, is what their actual intended use of is. So there's a complete disjoint there, and it's actually really notable for this reason. The thrust of the limb of bad faith that we're focusing on is the prevention of the trademark system being abused because of the intentional purpose of the applicant is not to secure a mark that will be used in accordance with the essential function of the trademark. Necessarily, cases of abuse are ordinarily cases of following the rules, but for a purpose that they're not there to further. So necessarily, or at least ordinarily, these cases will be cases where the rules are being followed, but that doesn't mean that there's no abuse. So my friend's attempt to answer it in this way really doesn't really amount to much more than saying I'm following the rules, so it's fine. And in my submission, that's just not meeting the point. That's what I detect as the first theme or strand in his case. The second is this. He muddles up the difference between actual use and an intention to use. And there's a theme that because there need not be actual use of a mark prior to application to register, there's the 5-year period after it's registered before it can be revoked for non-use. The argument is therefore the scheme must operate allowing an applicant to apply for whatever they like without intending to use for any purpose at all. There's a huge lacuna in that second theme in my submission, because you're moving from a situation where the system is being used properly, i.e. marks are being secured for the purpose the system is there for, both those that are being actually used already and those that are applied for in anticipation of intended use, they both are applications for the right purpose, and you're moving from that to one where they can be applied for without limit on purpose at all. That's the big difference. So by saying I don't actually have to use, therefore I don't even have to have an intention, he's muddling it up, and by doing so moving from a scheme where the two forms, actual use and intention to use, are both focused on the right purpose, to one that isn't limited to the right purpose. The third theme I detected in my friend's case is this. They repeatedly refer to their case, their contentions being TRIPS compliant. Now, my friend hopes, my lords, that by repeatedly claiming his contention is TRIPS compliant, you begin to think he must be right and I must be wrong. But that, in my submission, is quite wrong. TRIPS is an international agreement, like others in the intellectual property field, that sets minimum standards. Sets minimum standards that must be provided by national laws in particular areas. Many different legal schemes can comply with international agreements. It's a bit like someone claiming victory in a copyright case because their submission is not ruled out by the Berne Convention. Berne is an international agreement as to what national laws ought to apply under, for copyright. It's no help at all unless they can say their opponent's contention is ruled out. So it's nothing to the point for one side to say, look, I'm TRIPS compliant. All that means is that I can't rely upon TRIPS as an argument as to why he's wrong, but he can't the other way round either. And I haven't tried to say he's not TRIPS compliant. So that point gets him nowhere, but it's littered throughout his printed case in the hope that my lords start to think, well, if he's TRIPS compliant, that must be okay. And my lords, the fourth big picture point is another refrain we see in my friend's submission, that our law is a scheme of title by registration, not registration of title. And we see that, just for my lord's note, for instance, you see it in the heading on page 10 of his his printed case. And what's going on there is an advocate's sleight of hand. He's drawing attention to the fact that title cannot exist without registration, therefore can't exist prior to registration. This is not a system where there is notionally title that pre-exists which is then entered into the register. And the sleight of hand is this. Because registration is required for title to exist, the implicit suggestion is nothing else matters. And by registration, he simply means filling out the form and paying the fee. And what he's trying to suggest by this is that that's the alpha and omega of it. Of course, it's true the system is one whereby title doesn't exist other than when a mark is registered. But that doesn't mean that all that an applicant needs to do to secure registration is to fill in an application form for whatever monopoly they see fit and pay the fee. But that's the thrust of the point. But before I give my lords an outline of where I want to go in the detail of developing my submission, the final big picture point I want to make at this stage is this. One of the really striking things about Sky's case is this. It must be Sky's case that an applicant for a trademark can quite properly apply to register a mark in respect of every conceivable goods and service. It doesn't say so, perhaps not surprisingly, but it's a consequence of the argument he advances. Subject, of course, to any specific earlier right in some part of the register in respect of specific goods or services, but as a matter of principle, his case must be that an application may be made for absolutely everything, as long as you do it without using individual terms that fall foul of the IP translator point that I mentioned earlier, which of course you can address by using a longer list of terms cumulatively covering the whole area. The consequence of his argument is that an applicant is perfectly entitled to apply for absolutely everything, to occupy the entirety of the trademark real estate, as it were, and nothing can be done for many years. And by many years, it's longer than the 5 years from registration, because ordinarily it takes considerable time for a mark to actually be registered. You're often talking about a significantly extended period. I don't ask my lords to turn it up now, but we can see from the chronology in this case that's behind the facts and issues that the applications and the dates of registration for these marks were separated by a significant number of years, and the 5-year period doesn't start until they're actually registered. Now that's an overview or big picture. Can I just outline to my lords how I propose to address the remainder of my submissions? What I want to do first, if I may, is to spend a little bit of time explaining how the trademark system works and what it's for. And there are particular areas that I want to touch on there, like the IP translator point, so that my lords actually see what the big picture of the system is. Then I want to touch on the history of how these proceedings developed, and that's necessary for a variety of reasons. For example, to understand the procedural unfairness issue, but also to understand the case that was advanced at trial and the judge's assessment of likelihood of confusion compared to his assessment of passing off. When I've done that, I'll get stuck into the European cases on bad faith, turning some of them up, including Lint and Monopoly, and culminating in the CJEU case, decision in this case. I'm actually going to pick up the odd national decision as I go through, including the Court of Appeal's decision in Lidl, which was after the Court of Appeal's decision in this case, because it's looking at the same issues. And you see what Lord Justice Arnold thinks. Then I will address the big issue of whether bad faith requires dishonesty, a point that my friend contends for. And when I've done that, I will have covered some, but not all of the errors that we say are apparent in the Court of Appeal judgment, particularly as regards Lint and the dishonesty point. So when I've done that, I will deal with the rest of the errors that we've identified in our printed case to make sure that my lords have my submission on all of them. Then I'm going to explain what we say the correct application of European law involves, both as to the approach that should be taken and application of it in this specific case. Then I will turn to deal with the procedural unfairness issue, which I can deal with relatively briefly. And in fact, the remaining topics are all quite brief. The final two are the infringement argument and briskly, hopefully, the Brexit point. So that's what I plan to do, if that's convenient for my lords.
A lot of ground to cover by 3:30.
I know, there is a lot, but the last points, don't get too worried. The earlier ones are going to take the time, including explaining the system and what's happened in these proceedings. The last ones are much more brief. So let me start by turning to explain the trademark system as it exists under the regime we have under the 1994 Act and the European Trademarks Regulation. My lords know that those are the national and the European regime applicable to national marks and European trademarks respectively. The national regime was an implementation of a European Trademarks Directive which has been mirrored in the European Trademarks Regulation. So we're broadly talking about this, well, we are talking about the same law in both instances. Now, a trademark may be a word or a logo, or perhaps one of the more exotic signs, like a three-dimensional registration of the shape and appearance of packaging, or even the product itself. And the way the system works is you register it in respect of particular goods or services. So you go along and say, oh, this is the mark and this is what I want to register it in respect of. And the goods or services for which a mark is registered are entered in the register as words describing the goods or services the applicant has chosen to cover. And the register is organised in classes pursuant to what's called the NICE classification system. And this is important because it's a practical tool. It divides the universe of possible goods and services into, I think, nearly 50 classes. Mostly classes of goods, but services are included and separated into, I think, the last 10 or so classes that we have. And the classification narrows down how much of the register one needs to look at. To see, for example, what marks are already being registered for different types of clothing, I look in class 25. I don't have to search the entire register. And that would obviously be a nightmare. So that's one of the practical purposes and benefits of this classification system. Now, as I've said, within the registration, the words of the specification of goods and services are chosen by the applicant. And so if we just pause on that and consider what that means, it means the terms, whether it be just one term or a list of a handful of terms, can be at a level of generality chosen by the applicant. They choose the level of generality as well. So for an applicant from Jermyn Street, it could simply be shirts. Or a different applicant interested in sportswear may describe what they want at that level. For others with a broader remit, perhaps a list of skirts, dresses, blouses, whatever it may be. So the length of the list and the level of generality of the terms is chosen by the applicant. Now, one of the consequences of the computer age is that there are databases of terms that have been included and accepted on the register in other marks. And that might explain rather the increasing tendency to treat the process of applying for a trademark as simply selecting from these long lists that are already on the computer databases, leading to a mindset that one's buying a monopoly which can cover all these things if you say yes, or should cover them unless you positively decide to forego them. And that kind of decision, should I positively forego it, is a mindset that's apparent in the evidence filed by Sky. And frankly, the existence of these databases is probably why we see this increasing practice of trademark specifications being populated by basically covering the same thing in many different ways at many different levels of generality. You see somebody ticks the box for clothing, but they also tick the box for dresses, they also tick the box for skirts, they also tick the box for golf apparel, whatever it might be, and you're in effect covering the same things all over again. And that is an increasing tendency for trademark applicants. Now, can I just focus on another consequence of having the classification system and its purpose? It can have an impact on what the words in the specification mean. The classification system. And this is potentially quite important on the facts of this case. And that's obviously so because the practicality of what the classification system is supposed to provide is a registry divided into regions so the public know where to search. And it would be a problem if the wording in the specification in a different class actually was understood as spilling over into other classes. Because if you're searching, say, in class 25 for clothing, but something in another class actually covers clothing, you don't see it. So there's a problem. And can I show you a recent first instance decision of classification affecting the construction of the words in the specification, just to make that point good? It's tab 177. It's a decision of the General Court from the end of April.
I should tell you, we don't have tabs, so we need the electronic page number.
It's 177 is page 2779.
Yes, this is Mold Pro. Yes, events.
Yeah. And can I just flag this up to you, because it's a case that it actually only came out about a week or a little bit more than that before our printed case. It wasn't referred to in our printed case because it wasn't publicised and come to our attention by then. But it's included here.
I think I may have missed it. Is this the worldwide?
So it's 2779.
2779.
Thank you.
Right at the top it says Judgment of the General Court, 26th of April 2000.
I've got it now. Thank you.
Yeah. But I just wanted my lords to understand that it's not actually cross-referred to in our printed case. And this was actually a case about non-use. So not a bad faith case, it's about non-use, but it's focused on the construction of the specification and the impact of the classification on it. So it's on the point that I'm addressing my lords on. And it was an appeal from the cancellation proceedings in the EU IPO. So there is an appellate jurisdiction in the General Court up from the European Intellectual Property Office. And because it was non-use, the issue was that the proprietor had to show that it had used in respect of goods for which it was registered. So what goods it was registered for was crucially important. And the issue put shortly was that the registration for hose connection couplings had been made in class 17, which is a class for plastic goods. Class 6 is metallic. One of the ways, not the only way, but one of the ways the NIS classification separates things out is the material for which, of which products are made.
So if you can help me for a moment. This was an application under the European regulation, and does the regulation simply require you to indicate the classes for which you're seeking registration?
No. No. You put the words in, but you put them in a particular class.
I see.
I'm getting ahead of myself, but basically what had happened is that the goods were hose connectors. Yeah. They registered it in class 17, which means it's understood as plastic hose connectors.
So for example, if it were clothing, you couldn't simply tick the box for class 25. You'd have to specify whether you want it for shirts or trousers or whatever it is.
That's not a question I can just say yes or an answer yes or no to, because sometimes a class heading has some words which are too broad to be included because of the IP translator point, and sometimes some of the words are allowed to. So you do have to have words. You don't just tick a box. You have to have words. And I'm going to show my lord what they actually did here. Can we pick it up at paragraph 19 at the foot of page 2781? We see the court referring to the fact that the board, that's the Board of Appeal of the EU IPO, court below, had found that because the goods rapid release couplings for hoses and hose connection couplings had been registered in class 17, so the registration were for rapid release couplings for hoses and hose connection couplings. Those were the words. They'd been registered in class 17. Because of that, it didn't include those made of metallic components.
Sorry, can you help me as to what class 17 and class 6 are? They're the overriding description.
Class 17, for the purposes of this, is that it's limited to plastic.
Right.
Class 6 are metallic products. It's slightly more complicated than that because products may be in a different class altogether. It's only products that are not otherwise classified for a different way where the material counts. But for our purposes, there's a class for plastic, there's a class for metallic.
Thank you.
They'd registered plastic, and they were trying to show use on metallic.
Thank you.
But of course, the limitation to plastic isn't in the actual wording inserted in the specification. That was the hose couplings without limitation. And we can see the trademark proprietor sought to rely upon that. We see it disputed the reliance on the classification. This is paras 20 and 21 on page 2782, where you see the latter paragraph, you see them contending that the wording could include a large variety of goods irrespective of the material from which they are made, which of course in a different context it certainly could. The wording hose connectors can cover any hose connectors, but that's not the right approach, as paragraph 22 explains. The registration must be understood in the light of the Nice classification. In that case, it was the 9th edition, which was the relevant one. Now, paragraph 23 considers the submission that the Nice classification is an administrative thing, which of course, in a sense, it is, but it explains that where the description of the goods is so general that they may cover very different goods, it's possible to take account for the purposes of interpreting or as a precise indication of the designation of the goods and services. So you're taking account of the fact that you've put it in a particular class to construe the words as meaning those things in that class. Now, after describing how the Nice classification operates, referring to descriptions and explanatory notes, that's para 24, we see this at para 25. It's also apparent from the case law that the goods covered by the contested mark must be interpreted from a systematic point of view, having regard to the logic and the system inherent in the Nice classification, while taking into account the above-mentioned descriptions and explanatory notes, which are relevant in determining the nature and purpose of the goods in question. And the upshot, para 26, is that one doesn't confine analysis to the literal meaning, but one takes account of the classification of the goods. And then, my lords, there's an explanation in para 27 that the same point was relevant in cases where there's an assessment of what goods or services are covered in Article 8.1 cases, and that's basically earlier right cases. So you do the same then. And the conclusion, which is the key point for my purposes, is para 28 on page 2783, interpreting the meaning of goods with regard to the class in which they are registered is correct. And I say to my lords, it's no surprise because the classification system wouldn't work otherwise. One needs to know where to look. And you wouldn't be looking in the right place if you could have words entered into another class that actually covered goods in the class that you're looking. Now, I've taken the time to look at this point because we say it's the same issue when considering recasting or narrowing a term. You should be aware of that same issue. It's basically the point we addressed at paragraph 66 to 69 of our printed case. And it may be of some significance in our case because my client's activities are not class 38. They're not class 38. Yet if the selected goods and services in class 38 are not simply deleted, those where there's bad faith and we say you should just delete the term, but if they narrowed, you have to have an eye on this. You shouldn't narrow them to a way in which class 38 registration somehow has wording which is said to be identical to my client's activities, which are not class 38.
Can you just remind me what the wording of class 38 is?
Telecommunications, but it includes broadcasts as well.
Thank you.
This is a point directed to the narrowing of this.
It's a point,
terms.
yes.
Is that where we're going with this?
Yeah, it's a point directed to that, and it comes in again when on the argument that my friend wants to raise on infringement, and it dovetails with what I'm going to show you when I show you the history of the proceedings. And a point that was recognised by the Court of Appeal is that on the judge's analysis, there has to be identity of goods and services for there to be infringement. And that's why my friend wants to say, oh, look at the other ways of us identifying, of arguing infringement. He wants to get into a new argument of infringement, which he recognises is necessary if he hasn't got identity of goods and services. And the point that I'm making at this point is that something's going wrong if something registered in Class 38 is then recast in words which are held to cover something which is not Class 38. So that's why I'm taking the time to look at this aspect of the system.
You can't, by narrowing, jump from one class to another.
Exactly. Yeah. Now, we've been considering the width of the registration as regards goods and services of the trademark system thus far. There's another dimension to the extent of the registered real estate, as it were, or space available to the public, and that's the range of different marks that might be adopted. And so the range of goods and services and the range of marks are the two dimensions which are the building blocks of the way in which the present system look at extent of protection. Obviously, a trademark registered in respect of goods X gives an exclusive right to use of the mark in respect of all goods falling within the description X. But there's also what is sometimes called a penumbra of protection, and this comes into the picture when assessing infringement. It's an infringement issue, as we explain in paragraph 82 of our printed case. And there are two ways in which a trademark owner's protection is broader than just identical goods in respect of identical mark. First, the instances where there's not identity but similarity and a likelihood of confusion. And it may be identity of one of those two things and similarity of the other. So it could be similar mark, identical goods, such that there's a likelihood of confusion. And that is in fact the basis of the case advanced in closing in this case and the analysis carried out by the judge, as I will come on to explain. So similar mark, SkyKick is not the same as Sky, but identical goods. It's also possible for there to be infringement on a slightly different analysis where there's identical mark and similar goods, such again that there's likelihood of confusion, or even neither are identical but merely similar, but still overall such that there's a likelihood of confusion. So there's three ways in which the likelihood of confusion infringement, which is referred to as type B in the taxonomy we've been using, can arise.
It may be worth just interjecting here that none of that relies on reputation. This is similarity of goods.
Absolutely, and I'm just about to come to the other.
Similarity of marks.
Absolutely. My Lord's absolutely right, and it is worth making that point.
It doesn't require reputation, but if there is reputation, that may make a difference.
It's part of the overall assessment. My Lord's absolutely right. But none of those require reputation, and therefore, actually, if the mark is properly registered, so you've registered it and you're going to start next year, it can be infringed. Got no reputation because you haven't even used it yet. It can be infringed in all of those ways. But that is a penumbra of protection about the registration for what you've actually registered it for. Not actually what you've registered it for, because there's a difference either in the mark or the goods or both, but still close enough for overall for there to be a likelihood of confusion. So that's one form of penumbra around the registration. The other is where there is a reputation, and this one can be potentially very extensive because it applies to goods that are not even similar, but where there is a reputation and the defendant is taking unfair advantage of it or acting in a way that's detrimental to the distinctive character or repute of the mark, that's another way in which a mark can be infringed. So again, not using it within what it's been registered for, so another aspect of the penumbra, and that's type C infringement. So these are ways in which a trademark proprietor has protection beyond the precise goods and mark on the register. But what's really important that my Lords grasp about this is that is an aspect of infringement. You get that if you register it for what you use and intend to use anyway. And of course, if you register more broadly, you get this penumbra on top of what you've registered more broadly. So you're not only registering the penumbra, or perhaps type C if you're registering for everything, but you then get an additional broader penumbra around the very broad registration, if that's what you do. So I'm drawing this to my Lord's attention so that you see that there are ways in which a trademark owner is protected from people coming too close to what they register, even when they do it properly and register it for what they actually or intend to use. And that's how it's dealt with in infringement. Not, we say, by just saying, well, just register more broadly to give yourself that protection on the register.
Yep. So to say, just for the sake of argument, say I registered, say I was Mercedes, and I registered the word in relation to, and the three-pointed star, in relation to car-related products. And then somebody used one of those marks on luggage, say. If I'm following what you're saying, Mercedes could object to that, would be able to object to that, notwithstanding the fact that they hadn't registered the mark in relation to luggage.
Exactly. Quite likely, it might depend a little bit on how it's being done, but if it's obviously a rip-off of Mercedes on luggage, that's very likely to be type C infringement.
Yeah.
So you can protect against all of that by infringement provisions. Now, another important aspect of our system that my Lords have already heard me touch on, and I'm sure you're aware of it, but I must deal with it, is that you can apply for a mark before you commence trading, either at all or in the particular goods and services that we're concerned with. And that is an important practical convenience. One wouldn't want to make all the investment and gear up to make a particular product or provide a service under a particular mark, only to find someone else started some conflicting activity just before you're about to put the first product on the market. So one can understand why we do it, and it's absolutely no doubt that an application can be made in anticipation of intended use, and we provide for it. But a mark must be used in respect of goods and services, in respect of which it's registered. That much is common ground. It must be used within 5 years of registration. If not, it can be removed in totality, or it may be trimmed back if there's some use but not commensurate with the width of the specification. So it's common ground that it must in fact be used. But my friend, as I understand his case, says that there's only that requirement at the end of that 5-year period. There is not the kind of symmetry that we say that there is. We say there's a kind of symmetry between the requirements at the time of the application, which apply prospectively, and the non-use provisions, which apply retrospectively, looking to see whether there's actual use. And the symmetry is in the underlying idea that the registration should be commensurate with use. In the case of the retrospective assessment, it's easier because you just look back in time and see what's actually been done. But with the prospective assessment, one is concerned with intended use, either an intended continuation or an intended new use, or perhaps a mixture of both, subject to the point that my Lord raised with me, in that there will have to be a line drawn as to how firm that intended use is. But you're looking at applying with that being the purpose. That is your purpose, is the intended use of the mark. And the key point in my submission is that that is the heart of it from either end of the telescope. And use is also at the heart of the infringement assessment, because when one is carrying out, for instance, the assessment that my Lord Kitchen mentioned about where there doesn't have to be any reputation of a mark, so the likelihood of confusion assessment, what are you doing in working out whether there's a likelihood of confusion where the mark hasn't been used at all? Well, you are notionally deeming it to be used. You are thinking about deemed use of the mark that's registered, because that's what it's been registered in order to be doing in due course, and you're comparing that with what the defendant's doing and assessing whether there's a likelihood of confusion. So use is actually at the heart of that as well, even without marks that are in fact yet used, because you deem it to be used for your test. So use is at the heart of all of this. And it's not surprising, because use is what the trademark system is for. Marks that are going to be used. Now, can I just pause and consider a person seeking to apply for trademark protection, say, before they actually commence trading? From what I've explained to my lords, hopefully you can see that there are two dimensions of the space in which they can occupy on the register. First, the marks, the number of marks, the different marks themselves. They can apply for just one, or perhaps variants that are applied for. That may or may not be legitimate, depending on what their actual intended use is. And second, the extent of the goods and services. So, before you commence use, in terms of staking your claim, getting cows on some beds, as it were, the scope of the exclusive right you can seek can extend in these two dimensions. And at this point, it's convenient to mention defensive registrations. Defensive registrations are a tactic that are known in trademarks where a party applies not only to register what corresponds to its actual or intended use, but it seeks to extend their exclusive rights beyond that to cover things that are not actually intending to do. And the reason I'm introducing it here, having just identified that there are two dimensions in which you can engage in defensive registrations. And you've seen in our case we refer to it as registering the penumbra, because often what they're trying to do is to broaden the scope of protection so that they've got absolute protection, which is much broader, and they get a different penumbra. But in fact, it can be very broad indeed when they do it in the dimension of goods and services, because you can end up registering for almost everything. And so you can do it either way or both, and either is it a kind of defensive registration. If I register not only the mark I use, but things that are similar, so that I can not only complain about infringement of my mark that I'm using, but anything that's similar to my other registrations, I extend my protection. And I do the same if I register for goods and services other than the ones I intend to use. I stop people registering or using marks that are similar to mine that are nothing to do with what I'm doing, but because they may be the same or similar goods and services of the scope of my registration, which can be as broad as I like when I fill in the form. And if I have the mindset that this protection is all there to be had unless I decide to forego it, one can quickly see how you get into the position of specifications covering way more than a party actually intends to use. So the big picture point I want my lords to see on defensive registrations is there are two ways of broadly doing the same thing, both of which we say are illegitimate and an abuse of the system. The extra breadth of protection that you might be entitled to comes on the infringement side. It's illegitimate to try and have a bit of that on registration as well. But my friend's position is that's perfectly legitimate. Now, there are a couple...
So you say any form of defensive registration is illegitimate, i.e. comes within bad faith?
Yes, because inherent in what you're doing is registering in a dimension that you don't intend to use in order to keep other people off of it, so you're intending to use it for a purpose, the pure legal weapon, yeah. And we'll see we'll see a document that my friend himself is relying on where defensive registrations are identified, and that is explained. Now, can I move on to a couple of more specific points? The IP translator is something that I need to explain to my lords, because it is an important part of the context of some of this argument. And we address that in a section of our printed case at paras 87 to 95 on page 129. And the point in that case arose because a praxis had grown up of applying for the broad language used in the class headings for the NIS classification. And indeed, it was even worse than that. A practice had grown up whereby doing that was understood as applying for everything in the class, even if it didn't naturally fall within that wording. But the key thing for my lords to grasp about this is that the focus of this objection is the proposed registration. It's not concerned with the applicant and his intention or motivation.
I'm sorry, are you talking about the mark itself or its description?
Well, it's actually its description, but so the mark in the sense of if you include everything that's on the register about it.
Yeah. Yeah.
But not, it's not a point, my lord's quite right to pick me up on that, because it's ambiguous. It's not a point about the mark being descriptive or something like that. No. It could be any mark, but it's about the actual form of the registration, which is the mark and the words, and it is focused on the words. Formally, the issue is one of clarity and precision, which is not a ground of invalidity itself. So if it's accepted by the registry, you can't apply to invalidate on this ground. But it is still an issue to be addressed at the stage of registration. And the point is that some things are just too variable to be included as individual terms in a specification. And we've set out a key passage in paragraph 89 of our printed case, which is on page 129. And there are two ways we say that this is important. One is that when rewording a specification, the court ought to have regard to the rule, because one's considering a new term. That's one way, but the first and perhaps most important point is the one we touched on earlier. The fact that a term may be allowed in the sense that it's not absolutely prohibited for anyone in any circumstances doesn't mean when looking at that broad term in a specification and assessing bad faith, it's permissible for everyone, regardless of their actual intentional purpose. It's muddling up what you're actually looking at in these two different topics. My lords can perhaps appreciate that it can't be enough to simply argue a term has been held permissible in the sense of not prohibited by this consideration, because if that were so, one would never get into restricting terms that have been allowed in a specification under the non-use head. Because under non-use, a term which is not prohibited under IP translator may still be too broad, given the actual use.
For my part, I hadn't understood this was a point which was taken against you, but maybe I don't want to stop you, but I do question whether or not this is actually a particular point in issue.
The reason it's an issue, as I understand the way the case is put, is because he identifies decisions or a practice note that says this is okay, when this is the consideration, this term is okay, and he says, well, we've applied for it, so it's okay.
Well, I don't want to deflect you, but I hadn't really understood that to be the thrust of Mr. Hobbs's case.
I hope it's not, but my lords know the answer if it is part of his case. I'll move on, because I was going to show you where I thought he was saying that, but my lords know the answer that I give if that is what he's saying. Another area I wanted to touch on is this. It's something we explain in our printed case at paras 96 to 98. What actually matters in trademark law is the core of what terms cover. And we refer to Lord Justice Jacobs' well-known warning that this is particularly important in the context of services because they're often more vague. That's the read executive point we refer to in paragraph 96. And there's a related point when one considers what a trader is actually doing. It's the same kind of consideration. One should look at what consumers perceive as being provided in terms of the goods and services. And we illustrate this by suggesting that the supplier of electronic toys is not using the mark in respect of electronic components such as resistors and capacitors. And a restaurateur is not considered to be in the business of providing access to lavatories, even though both of them are doing it. The point, my lord, is one looks at the core of what the trader is doing, what the reasonable consumer perceive as being part and parcel of what's being supplied. And just to foreshadow that and give an example of the particular significance of that in this case, the provision of software that enables access to what a business is perceived of actually providing does not mean that they are in the software business. Let me give you a concrete example. Almost every business now seems to have an app that you can get. An app from your favourite pizza delivery company doesn't make Domino's, or whichever one it is, in the business of software or using Domino's in respect of software. It's just part of the means that they make available to people so that they can get access to their pizzas. Likewise, software is in almost every good that you can think of now, a dishwasher, a coffee machine. Businesses providing equipment incorporating software, even if they provide for it to be updated, is not in the business of software. And my lords, the significance of that in the picture that my lords are dealing with is software to enable mobile access to Sky Sports football coverage or other content of its broadcast platforms, or software for its bookmaker services that you get online, software in its set-top boxes. All of these things are just incidental to the provision of what they're actually providing.
And your submissions, I understand it, they're not using the mark in relation to software at all in these cases.
Indeed, they're not.
Whether that's open to you or not, and to what extent it's open to you, I'm sure you'll come to. But certainly for my part, I understand the submission.
Yeah. Now, can I highlight, as I said, a little bit of the key information about the way the proceedings are developed? And I'm going to do this as briskly as I can, but it's necessary for my lord to have in mind a bit of the detail of how it developed, or various of the issues that arise. As you know, they were commenced way back in May 2016, where Sky selected 5 of its registrations to assert, 4 European and 1 UK national registration. None of them had been registered for 5 years, so were not susceptible to revocation for non-use. Just as an aside, my friend seeks to make something of the fact that for some, but crucially not all, we may have been able to bring a non-use attack in before trial. And I confess I'm at a loss to understand that point, because there is no utility in raising a point that would not apply to all of the registrations. But just so that I'm fair about it, when the proceedings were commenced, we couldn't, but there was a debate about whether we could in respect of some of them before trial, and the judge expressed the view that we could have done, but it wouldn't have applied to all of them. So they were not susceptible to that non-use attack at that point. And the way the pleaded case was advanced by Sky was not limited in any way as regards the goods and services in the specifications that were relied upon. It was simply said that our activities infringed without limiting which goods were relied upon. As I think my lords appreciate, setting out the totality of the specifications is unrealistic. The judge hasn't tried to do it, neither has either of the parties. And at that stage, Sky provided what one might call edited highlights of the specifications, while making it clear it wasn't being limited. And even that extended over nearly 8 pages of the pleading. Can I quickly show you that? It's tab 57. Page 1166. This is the pleading. It starts at 1166. The trademarks are set out from the foot of 1167 right through to 1175. So if you just skim through those pages through to 1175, you can see it's about a third of the way down on 1175 where it finishes. But if you just skip back a page or 2 pages to 1173 and 1174, you see dense wording listing endless goods or services. I think this is the national registration they're relying upon. That is the way it was pleaded. Even the edited highlights approach is completely unwieldy. But that's the pleaded case. And my lords know that my clients applied to revoke on the ground of bad faith. Given that there's criticism as to the way the case was framed, I should quickly show you that. We can see that in the amended defence and counterclaim, tab 58, page 1279. The document starts on that page. The allegation is on 1295 in the counterclaim. The particulars start at the top of the next page, 1296, and extend to midway through the next page, 1297. Can I pick out some key points briefly? We see right at the beginning, so immediately under the heading of bad faith, it's the extreme breadth of the specification that's complained of. That's subparagraph A.
So, sorry, which page are you on?
1296, just under the particulars of bad faith. Sorry, that's that section that I'm looking at. So we make the allegation and then we give particulars as is the norm. And the first bit is the extreme breadth of the specification. That's followed by contending that for the European trademarks and the national mark, that's subparas B and C respectively, Sky didn't intend to use the marks in connection with all the goods and services. For good measure, paragraph D makes it clear the allegation includes that it can be inferred from the breadth of the specification. Paragraph F makes specific reference to section 32.3, which is the declaration they had to make under UK national law, which we'll come to when we look at the case, the decision of the CJEU in this case. It's basically where they have to say that they did intend to use. Paragraph G specifically alleges that Sky knew it was not using and had no intention to use for all goods and services, and this was the time that each was applied for. So that paragraph is alleging this is a deliberate thing. Para H is making a specific point about the effect on third parties who it was alleged they knew would want to use the term Sky in the cloud computing field, which is obviously what my clients are concerned with. And paragraph I is the contention that despite this knowledge, the application was deliberately overbroad and unfairly extended proprietary rights. Well, that's the pleading on which the parties proceeded to trial. Sky filed its evidence and was perfectly able to address the allegation of bad faith. In fact, that evidence was filed before Sky proposed to focus on what became the selected goods and services at trial. Just for my lord's note, the trial was set for January 2018. The evidence was exchanged early November 2017. That was over a month before the proposal on the 8th of December to restrict the issues considered at trial to what would eventually end up in closing. It wasn't exactly the same at that point, but in closing it became the selected goods and services. At that point, they hadn't formally abandoned the rest of the case. That came much later, but the proposal was to focus on that at trial. Now, there is a point about the selected goods and services, one particular aspect of it that my lords need to have in mind as well. And I'm addressing...
Sorry, just before we come to that,
Yeah.
can I just ask you, on page 1296, at E, you say there's an obligation in EU law, well, the pleading was, there's an obligation in EU law for applicants to make their applications in good faith. And as I understand it, that's not an express requirement of the legislation, but something that's been established in the case law. Is that right?
I'm sorry, do you mean 1296?
Yes. I think I do, yes.
Yep. And which subparagraph, sorry, Alan? E. Well, there is an obligation not to make them in bad faith, so it's...
Yeah. Well, yes, I just wanted to ask about E and F. So far as the EU law is concerned,
I don't think we're saying
am I right in
anything...
thinking this is simply a requirement that's been developed in the case law of the Court of Justice?
No, I don't think this is doing anything more than saying that you're not allowed to apply in bad faith.
That's right.
Well, is that a...
But
yeah.
An application is bad if it's applied for in bad faith.
That's in the regulation, is it?
Yes.
Right.
Yes.
Okay.
And it's an express provision. It's in the regulation, the directive, and it's, for instance, it's transposed into our Act in Section 3.6.
Fine. That's fine.
Okay. Sure. The detail on the selected goods and services, which is potentially important, is the detail we foreshadowed in para 30 onwards in our printed case on page 120. We've set out the 8 individual terms. They're not all in all 5 specifications, but they're in one or more. The first 7 are all taken verbatim from one or more. But where this is not the case is the last one. And the entry in Class 38, which Sky put forward as computer services for accessing and retrieving information/data via a computer or computer network.
Sorry, you're reading from paragraph
30 on page...
Paragraph 30 on page 120, we've set them out. Sorry, I'm taking this too quickly.
My fault entirely. I've got it now.
And the point I was making to my lords is that no issue with the first 7, all taken exactly as they appear in one or more of the specifications. The last one, not so. And what they've done is put forward a term which is computer services for accessing and retrieving information/data via a computer or computer network. And the slash there has been included to avoid having to more blatantly change an and to an or. What's happened is that there was a term which is rather longer worded, as we set out in paragraph 31. It's computer services for accessing and retrieving information, messages, text, sound, images, and data via a computer or computer network. Now, one might have taken that and between images and data as a conjunctive, so that the services covered actually had to provide access and retrieval for all of those things, not just one of them. Sky's obviously plainly taken it as a disjunctive, so taking the term as covering all services which enable it for just one of those things. And what they've done is chosen to put forward only part of the term, leaving out computer services for accessing and retrieving messages, text, sound, or images from what it put forward. And indeed, subsequently, when it abandoned its case on the rest of the specification, it's abandoned a case of infringement as regards that remaining part of the term, when the judge allowed them to do that. So they've abandoned any suggestion of infringement of computer services for accessing and retrieving messages, text, sound, or images. It keeps that, regardless of what happens, like it keeps its registration for Gladstone bags, by virtue of formally dropping the case. Now, I'm labouring this point because it's important to understand that when deciding what to do about the broader term, if you conclude that it's applied for in bad faith, if you conclude one might otherwise have done anything other than simply delete the terms affected by bad faith, We say it's important to know that Sky is in fact keeping the part of the term it didn't put forward or allege SkyKick infringed. There's the added complication that I mentioned earlier about you shouldn't frame it in ways that covers something that's not in Class 38. But when we get to it, you'll see that what the judge did is basically reframe it in language. I don't think he realised that they were keeping these other things, because he reframed it, not using exactly the language of what was kept, but broadly covering it. So retrieving, I think it was audio, visual and documents or something like that. So, but it's very similar to what they actually chose not to put forward. And so it's quite important that my lords understand that the idea that that particular term is recast in any way, you've got to know that actually what they were left with is good enough anyway. And it's important, particularly important, because it's the one term on the judge's analysis after the Court of Appeal have overturned email services. This is the one term that my clients are still susceptible to being held to be infringing. So it's really important that my lords understand that. It's a recast wording which broadly is covering that which they didn't put forward, and it's the other aspect of infringement before the trial judge that wasn't overturned by the Court of Appeal. And that's why I'm labouring the point. My lords are probably sitting there thinking, there's an awful lot of detail on this, how does it matter? But it really does matter. It really does matter.
So what Mr. Justice, or Lord Justice Arnold, did in terms of cutting back, you say actually doesn't quite serve your purposes either?
Not on his findings. No, it doesn't. But what is quite apparent is that one can't help but conclude looking at it, he can't have understood that what he was doing was in substance giving them, by rewording the broader aspects of this term, he in substance gave them the bit of it that they left out, they deliberately left out. I mean, the point that I've just made to my lord, it doesn't suit my purpose either, is subject, of course, to the point that I make about it can't be right that you reframe something in Class 38 to catch something in Class 42 as well. But certainly on his analysis, that's what he did.
And which particular part do you say falls into Class 42?
What falls into Class 42 is if you read it as understanding the en bloc transfer of files for backup for disaster recovery. It's not to do with the kind of individual communication between two individuals in telecommunication or broadcast where you're broadcasting from one to many individuals. This is just a way of transferring data en bloc so that it can then be recovered. So it's class 42, not class 48, but it's been framed in a way which is then read or understood as covering what's class 42. Now,
is this what's meant, I have to confess I didn't understand the term, is this what's meant by email migration?
Well, not quite, no, because this is the backup. Yes. There are two things that they're similar though. That both of them. Let me just take a minute so that my lords understand what my clients are actually doing. Businesses that have large amounts of data may want them transferred and manipulated in a particular way for a particular purpose. And there are two purposes that are key for the two things that my clients do. One was the migration of email data, so the entirety of a corporation's email data, when Microsoft moved over to having email in the cloud. People had to move their systems over. Work was needed. Yeah. And it was a facility that IT professionals used with their own clients to basically move everybody's data from what might be a server either on their premises or nearby to being in the cloud. So that's the email migration. On block, large amounts of data. The backup is still on block, large amounts of data, but you're not migrating so you've now got an email system in the cloud. What you're doing is backing up all your data to recover from disaster, but you're still doing it pretty much doing the same kind of thing. Now, there are a few aspects of the findings of the judge which are important to look at in my submission in his judgment, and I don't mean to dwell on the ones which we all know are really important, like the strategy and so forth. At this point in time, it's the assessment as to infringement that I want to address, because my lords hopefully will have understood that I say that his assessment depends upon and requires identical services or goods. And I want my lords to understand why I say that, and I say the Court of Appeal recognised that, and that's an important part of my explanation to my lords, that unless they are left with a specification that covers exactly what we are doing, on the judge's findings of infringement don't apply. It's got to be identical. Unless they are left with a specification that covers what we are doing, there is no infringement on the analysis of the judge. Now, and that is why, just to be absolutely clear, why my friend seeks to raise the suggestion that my lord should undertake a fresh analysis of infringement under Type B, where there's just similarity of goods and services. He knows that if he doesn't hang on to something which is identical, there's no infringement, and that's why he's persuading you to embark upon that. Now, the point was recognised by the Court of Appeal, and let me start by just showing you them recognising it, because it's a quicker way of identifying it. So it's tab 14, page 275. Now, of course, the point didn't matter to the overall outcome in the Court of Appeal, because they decided that they were going to reverse what the judge did, and they kept everything. But they did consider it. It's in a section that starts at paragraph 131, referring. So it's page 275, 131. Referring to the fact the judge had concluded that first, the migration service was identical to electronic mail services, and second, where there was identity, meaning of that which is covered in the specification, there was likelihood of confusion. And they specifically refer to the judgment at para 302 on this latter point. And that is a reference to the assessment the judge carried out based upon and relying upon identity of goods and services covered by the specification of and SkyKick's activities, and we'll come to it in a minute. And so the judge's conclusion as to likelihood of confusion was an overall assessment relying upon that. And what we then have in Sir Christopher Floyd's judgment, so I'm still in the Court of Appeal judgment, this is paras 132 to 137, it's a discussion of how what the judge had done was to conclude that the term electronic mail services extended to services related to electronic mail.
Is this the phrase being construed, electronic mail services? Is that part of Sky's description of the mark?
Yeah, it's one of the terms that they picked out in the selected goods and services. So it's not just there; it's one of the things that the trial was fighting about.
Yep.
Yeah, although Mr. Barron reminds me, we don't think it's actually in the 8 pages of pleading, but be that as it may, so the fight was, is it identical? And the judge had construed electronic mail services as anything related to electronic mail. And this was covered because SkyKick's service migrated en bloc email data to the cloud. And we see in this passage a reference to the important warning of Lord Justice Jacob in Read and Read, to which I've already referred. That's bridging pages 201 to 202. And the conclusion is the judge had construed the term too broadly. It didn't extend to everything that related to it. The key paragraph for my purpose on this point is para 138 on page 276. Sir Christopher explained in the first part of it that SkyKick service would not be considered ancillary feature of the email service, but a different service. The key point we see in the middle of the paragraph, moving email data en bloc, is just not the same thing. Indeed, it's not. As I say, it's not even in the same class. And Sir Christopher then explains that SkyKick services, that's the en bloc moving of emails, might have been similar, but that would have required a factual investigation the judge had not undertaken. And further, and this is the key point, it would have also required a reassessment that difference would have had on the conclusion of confusion. So the upshot is Sir Christopher would have allowed the appeal on cloud migration. And the point I want my lords to see at this stage, though, is that for the judge's assessment to apply, there needs to be identity of goods and services in the specification with SkyKick's activities. And this is the Court of Appeal recognising that, saying that there isn't, and they would have allowed the appeal.
You embrace this part of the Court of Appeal's reasoning?
Certainly that, but yeah. And it's, all they're really doing there is recognising that you need identity of goods and services on the judge's assessment and taking a different view on the construction of email services. Because, of course, email services they keep anyway. They don't attack that for bad faith. They keep that anyway. So, at the moment, the Court of Appeal have said we don't infringe email services because the test or the analysis that the judge carried out required identity, and there isn't. It's a different service. Now, my lords, that actually also reflects the way the case was put at trial, identity of services, as we explain in our written case at paras 316 to 318. That's page 162 of the electronic bundle. I wasn't proposing to go through the materials that we've identified here one by one, just draw attention to them because we've set some important parts out, including Sky's closing argument, and the paragraph in the judgment reflected the argument that Sky was one of identity of goods and services. It's enough just to highlight what we set out in paragraph 317 at C. Although the section was headed identity stroke similarity, the case was solely put on the basis of identity of goods and services, which is why the judge recorded the case in that way. The reference for my lords, I'm not going to turn it up now, is para 295 on page 377. And we also say this, it dovetails with the finding on passing off, which was to the opposite effect. The opposite effect, there was no passing off, and the judge emphasised the difference between the test for trademark and passing off in two places in his judgment. The first is para 296, so that's on page 377 of the bundle. This is a section addressing trademark infringement. It's in fact immediately following the paragraph 295 setting out Sky's case as to identity of goods and services. And 296 deals with the submission made by Mr. Mallinitz that the goods and services supplied were different to those marketed by Sky, which the judge accepted, and explained that it was irrelevant because it's not the relevant comparison for trademark infringement. What you're looking at is what's covered. I'm pausing there to make it absolutely clear we have no quarrel at all with the judge on this point. He's absolutely right that for trademark, the test is not what they're actually doing, but what's covered. But he's pointing out that what they're actually doing is different to SkyKick's. And we do say where we have a case of this kind, where a party's been pursuing a deliberate strategy of applying for and securing excessively broad specifications not commensurate with actual or intended use to use as legal weapons, how can it be the result, many years after the event, 2018, when the judge tried the case, that it secures for its registration that were made pursuant to that strategy a monopoly that extends beyond its actual activities, not just assessed at the date of the application, but those in the meantime undertaken. It could, in theory, happen if they came along and explained why they applied for something which didn't actually pan out in the way that they had anticipated. So it's not impossible, but it is notable. And of course, we have nothing of that kind here, the explanation as to why they are extending into something which is different. Now, that's the first place where the difference between the passing off and the trademark infringement test is mentioned. The other place, which is absolutely key, is para 356 on page 394 of the bundle.
Sorry, references again, please.
394 page, para 356.
Thank you.
And in this paragraph, I'm about 5 lines down into the paragraph, the judge explains that the assessment as to misrepresentation in passing off is very similar to that which one looks at for type B trademark infringement. But he identifies 2 important differences. The first was we're looking at Sky's actual use of the marks for passing off, rather than deemed use by virtue of the specifications. That's the point we just saw. Actual use is not what counts for trademark infringement, but it does for passing off. That militates against a misrepresentation in passing off, as the judge goes on to point out in this case. And that's because it's different goods and services. And the other factor is that in passing off, Sky could rely upon basically what was called the Sky formative marks, and that's where Sky is used with other words as a kind of series of sub-brands. And that was a factor that actually operated the other way round and supported a misrepresentation. And my Lord, see, at the end of the paragraph, the judge concluded the balance was tipped in SkyKick's favour, so there was no passing off, no misrepresentation. So despite that second difference actually being in favour, the first difference, that of looking at the use which was different, was enough to push it the other way, so you had a different result. So the upshot, my lords, is when one carries out the assessment looking at deemed use in respect of what's covered where there's identity, there is confusion, but when one looks at use where there isn't identity because it's different, there is none. And so, as I say to my lords, it just dovetails with the point that we saw that in the Court of Appeal judgment, that the assessment that Lord Justice Arnold carried out, consistent with the case that would have advanced in front of him on trademark, depended upon and incorporated identity of goods and services. And that's why we say...
One has to be a little bit careful, doesn't one, about drawing a conclusion from the passing off finding in relation to...
You do have to be a little... Let me tell...
But there are a whole range of considerations come into passing off which which do not apply to trademarks, and correspondingly in relation to trademarks considerations apply which don't
Well, in some other cases,
arise in some cases there may be a direct overlap, but
well, in this case I do say it is legitimate, the point I'm making, my lord, because the judge identified just two factors that he was saying were different. And the only one that pushed it the other way was the one that I've identified. So my lord's absolutely right that I can't just say this is always going to be the case, but I'm just pointing out that the judge basically was saying it's the same assessment apart from these two things pushing in either direction. But let me be absolutely clear, you do still have to be careful because the extent of the difference may still be part of the picture. So I don't want to overplay the passing off link. I really don't, because the extent of the difference is still something that you need to know that you're taking into account. So, but all I'm drawing attention to is that that distinction was really important on both findings, whether it's the same or not, and they dovetail together. Now, I've been longer than I'd hoped before actually getting to the European cases. Can I turn to them now? And what we say is that they show that bad faith extends to a variety of circumstances. So it's broader than just cases where the applicant applies for an exclusive right, where they don't intend to use the registration to protect commensurate use. So it's broader. And we've identified examples at para 116 of our printed case, so that's on page 132 and 133. So in subparagraphs A to G, 7 examples. And they're instances that either were determined could be bad faith, and I say that in cases where there's just guidance as to what the court, the referring court, needs to take into account, or were bad faith, for example, in general court cases on appeal for EI from the EU IPO, where they actually have to decide whether it was bad faith in the case before them.
I'm sorry, which paragraph of your written case?
I'm looking at the list of cases that we've or the examples we've identified on 116 is the paragraph, and it's pages 132 to 133 of the electronic bundle, and there's subparagraphs A to G. And the point that I was just trying to be absolutely clear about is that some of them are cases where they find it is bad faith, and other cases which are just references where the actual conclusion is not a matter for the court. They identify what might be bad faith. And I don't want my laws to miss that there's a mixture of those things going on there. And I'm going to look through a few, particularly those that pertain to what we might call registering rights defensively, defensive registrations, and those that show dishonesty in the sense that it's usually used in these courts is not required. So I'm actually going to skip over the first one, the obvious case of applying to register a mark known to be that of a third party. And if I can, please first pick it up at subparagraph B. That's the Monopoly Hasbro case. And I've already touched on that a little bit to highlight what it's about. It's about something, we're basically trying to avoid the consequence of the 5-year period running out at the beginning of a registration. And it's in page 2582. So it's actually tab 161 for those that got tabs. But 2582. I'm actually picking it up in the middle of the case, that just for your reference, that begins on 2575. And we're picking up where the law's being considered. Paragraph 55, after the citation of some of the existing case law, including linked, which we'll come to, the court states that it follows from the principles governing EU trademark law and from the rules relating to proof of use set out above, that although an exclusive right is conferred on the proprietor of a mark, the exclusive right can be protected only if on expiry of the 5-year grace period the proprietor is able to prove genuine use. Such a system balances out the legitimate interests of the trademark proprietor on the one hand and those of its competitors on the other. So an indication we're concerned to balance interests not only of the proprietor but of other traders. 56 makes the point that the absence of a factor held to be relevant for the purposes of establishing bad faith in an earlier case doesn't preclude a finding in another case, in substance simply saying different circumstances may be a different assessment. And if we pick it up at 61 on page 2584, here we see a recitation of the contents of the decision being appealed. And I'm going to just draw attention to this because it refers later on to these contents of the paragraphs below, so it's important for my lords to know what they say. 75 of the decision below recorded that it was apparent from the testimony given at the hearing, first of all, that being able to rely on a registration without the need to prove use was a benefit to the applicant and was considered by all brand owners, so in effect a claim everyone considered it. Next, that it was not the sole motivator in any of the successive filings. And lastly, if a company owned multiple marks of different ages, it was sensible for it to oppose a mark filed later on the basis of the recent one, which was not subject to the proof of use requirement. They do that to reduce costs. So that's that paragraph. The next paragraph, 62, addresses 77 of the decision below, and this was the evidence that it was accepted industry practice at the time for companies to file applications for trademarks that were already the subject of existing registrations, and to include in those new applications the goods or services covered in the earlier marks. So basically Hasbro was saying everybody's doing it. Paragraph 63 records the conclusion at paragraph 79 of the decision below that the applicant had knowingly refiled an application for registration of the monopoly mark, so it covered goods and services which were already covered by earlier marks. The applicant had admitted the advantage of the strategy was that it would not have to prove genuine use of the mark in opposition proceedings, which was one of the factors which the applicant considered when it filed the mark. And indeed, it saw no other commercial logic. Paragraph 64 makes the point that the fact it was argued to be industry practice clearly implied that the strategy was intentional, and that's important because it is subjective intent. Now, I've taken my lord to those paragraphs because as we see when we move on, there's a reference back to what those paragraphs below said, so it's important to understand those later paragraphs to know what they're talking about. If we drop down to 71 towards the foot of page 2585, we see the court says that in circumstances here the applicant's aim was, inter alia by its own admission, that of not having to prove use of the contested mark, thus extending with regard to earlier marks the 5-year grace period. Now paragraph 72 is important. It points out that not only is the filing strategy seeking to circumvent the rule relating to proof of use inconsistent with the objectives pursued by the European Trademark Regulation, but it calls to mind a case of an abuse of law, which they explain is formal observance of conditions laid down by rules, but where the purpose of the rules is not being achieved. That's what this is all about. It's an abuse. And it goes on with an intention to obtain an advantage from the rules by creating artificially the conditions laid down for obtaining it. Here they were seeking to obtain the advantage of having a young registration for that which they'd actually had registered for years.
And it would be abusive, as I understand your submission, to make successive applications for the same mark on the basis that one would, in that way, evergreen your application.
Yeah, and that's exactly the other way in which bad faith was put in the Little case, which we'll come to, and both of them were successful. But my lord's absolutely right, yes. Evergreening. Let me be absolutely clear. If you're registering the same mark, people do make successive applications in circumstances where you might have an update of a logo and things like that. We're not talking about that kind of thing. You've just got exactly the same word mark, and I just apply it again and again. It's exactly what they did here. I mean, they weren't doing it here to worry about actually being knocked off the register. They were doing it here for what one might think is a more trivial reason, because they had actually been using the mark. They just didn't want to bother to have to prove it. So when they were using it in oppositions, they didn't want to have to bother to actually have to prove it.
Well, do we know that specifically? I mean, I'm not. All I'm concerned about is that you don't overstate your submission.
No, not 61. I'm told it's 61.
71.
61 is talking about that, and I'm pretty sure there's a specific mention of not having to turn up at opposition hearings.
Certainly not proving the use. I understand the submission, and the court says that specifically, but I understood your submission to go further and say that they had all the relevant use and they could have put it in.
Well, we'll come to it, because one of their submissions was that it did no harm because they could have proved use.
I see.
So we will come to it. And
Yeah.
the distinction I was trying to draw for my lord, and I don't think I am overstating it, is you might do it, this evergreening conduct, in order to avoid losing your mark. You apply every 5 years or so that you keep it, because somebody might come along and knock it off because you haven't used it and you can't prove use. Hasbro was a rather strange case where they could prove use, they just didn't want to bother to go to the expense of it. And that's what the whole basis of the "it didn't do any harm" submission, which we'll hopefully come to. But to answer my lord's broader point, absolutely my contention is that applying every 5 years to avoid the use requirements is bad faith. It's not slap bang in the abuse of the kind where there's no intention to use and you want to use it as a legal weapon. It's abusing the rules in a different way, in this case, to avoid the requirement to prove use in oppositions.
Yeah. Well, that seems to be what they're saying, that to try to circumvent the rule relating to proof of use is inconsistent with the objectives pursued by the regulation.
Yeah, exactly. But one of the objective of the regulation is that you can have a registration and you've got a period of time because of the idea that you should be able to apply before you use it in anticipation of use. But when your registration becomes of a particular age, if you want to be in the scheme and play by the rules, you've got to prove that you've been using it. And what Hasbro wanted to do is say, well, I can just apply again, and it's cheaper to apply again. And they just wanted to avoid it.
And that's the point you make in 116 little b.
Yes. Yeah, exactly. It's an example of the kind of thing. And the reason that this is actually really important is because it highlights two things. One is, it's obvious dishonesty in the sense that English lawyers understand telling lies or that kind of thing, deceit, is not required, because they were absolutely frank about what they were doing. It also highlights that this is about using the system in a way that was not intended, abusing it. So making applications in a way that is not intended to be used. It is about abuse of law, abuse of the system, sorry. And so the application, if it is abusive, it's being used in a way that's not intended, is made in bad faith. And this is a case where they obviously did intend to carry on using it. Just for completeness, the no harm caused, because they could have proved use anyway, was rejected at para 82 on page 2587.
Reported in 79, the submission.
Yeah. Absolutely, yeah. The submission's introduced at 79 and then rejected at 82. So that's why I've picked this one out, because what it really does show is that if you've got a purpose, in fact, it doesn't have to be the only purpose, you saw that there were other purposes, but if you've got a purpose which is using the system in a way that is not how it's set up intended to be, and in particular doing it to get round the provision which is supposed to balance the interests of the trademark proprietor with other traders, you're doing that. Applying for a mark it is in bad faith. You can be as honest about it as you like. The next case is Lint, which is very important.
In this example, you can see a clear conflict with the scheme of regulation. I mean, the scheme is you get 5 years to use it. If you haven't used it within that time, it gets struck off. And the repeat application, the evergreening, as the Lord says, is designed to circumvent that. It's gaming the
system. But we say applying for a mark that is going to be used as a pure legal weapon in the sense that I explained earlier, to basically keep people from coming anywhere close to what your registration should be, registering the penumbra, which should be dealt with on the infringement provisions, is also gaming the system, because you are not applying for it as regards all or some of the goods and services for the purpose that the system is there for. And I'm not just extending Hasbro, I say that's what the case is, and in particular the decision in our case of the ECJ says. Now the next case is Lint, which is important given the treatment of it by the Court of Appeal. It's a decision from 2009, which is it's in. So I've only got the tab references. It's in 153 tab reference, which would be 2472. It's actually we got the decision of the Advocate General Sharpston and the judgment of the court respectively. And can I, before we get into the detail of it, can I outline the facts, because it's a really quite peculiar set of circumstances. The case concerned Lint chocolate bunnies. There's a picture of it on the first page there. And it's quite a specific point. Again, there was no suggestion of any lack of intention to use. And Lint had for many years been making these bunnies, and others had as well. They hadn't had a registration, and they applied to register the shape and appearance of the bunny as a three-dimensional trademark. And you'll immediately see that we're getting into an area where trademark protection is something you need to be a bit careful about, because it may give a monopoly that stops others actually marketing comparable products rather than just an ordinary sign on a packet or whatever it may be. And a further crucial piece of the factual matrix was that others for many years had been making their own chocolate bunnies, and there was a substantial long-standing use by others which enjoyed a degree of legal protection under different laws, national laws, for example, unfair competition in Austria. So there was a degree of protection, and there was this kind of equilibrium or coexistence where Lint and others have been making bunnies and have been able, under national laws, to prevent identical or perhaps very close to identical looking bunnies. And by applying for the trademark and then enforcing it, Lint was significantly broadening protection. Not protection of a trademark that it already had, but the protection that it already had under national law, which was quite narrow to only identical bunnies or close to identical. So it was applying for and securing a right which amounted to a protection against similar bunnies, and in particular, perhaps that of the defendant, Halsworth, whose bunny was shown, I think, on the next page, where the name wasn't visible. I think it was only visible underneath, so it didn't have anything on it to distinguish it. So consequently, that was confusingly similar. Now, so it's, and the issue was whether by applying for a right that would then have been broader and potentially caught these people that had already been trading for many years, the application was in bad faith. So quite a nuanced situation. And before we look at the judgment of the court, can we start with the opinion of the Advocate General? So this is 2472. And the first paragraph I want to draw attention to is paragraph AG 41 on page 2481. At the end of the section explaining how the provision fits with other provisions concerning relative grounds for objection to a trademark, the Advocate General explains bad faith is an inherent defect in the application rather than in the trademark, which fundamentally vitiates the registration regardless of other circumstances. And what she means by this...
Sorry, where are you?
2484 page, paragraph AG 41.
41, thank you.
Second bit at the bottom.
Yep, thank you.
And the distinction that she's drawing attention to, a defect in the application rather than the trademark, is that the mark may well be one that could have been registered, for example, if the motivation or purpose of the applicant was different. There's nothing per se wrong with the mark, and by that I include the words that you've included. It's the fact or the reason behind why you're doing it. And it can, indeed often will be a mark that's not objectionable on one or other of the other grounds. It's an objection concerning the application itself. And not to put too fine a point on it, and to repeat what we've just seen in Monopoly, it's where you're applying in a way that involves using the system in some way that's not consistent with the purpose of the system or the purpose of the trademark. It's an abuse. That's what she's getting at there. Now, can we pick it up at paragraph 48 on 2486? And the reason I'm drawing attention to this is here we see why there is any mention in this case of a situation where a marker is applied for with no intention of using the mark. So in paragraph 48, we see the Commission had made a submission at the hearing, which the Advocate General thought was different to the written submission. Anyway, it made a submission that bad faith was in fact narrow, so that the only thing that amounted to bad faith was the registration of a trademark with no intention to use it, but in order to prevent others from using it. And we see that the Commission had pointed out and said it was a corollary to Article 51A. That's the non-use provision. And they were probably, they're pointing really to the kind of symmetry that I've identified between the bad faith prospective and the non-use retrospective assessment. But they were trying to say that it was the only thing that bad faith covered. And obviously that would have been important in this case because Lint were going to use it. So it was crucial. And we see the Advocate General say in paragraph AG 49, she wasn't convinced by the submission, although she had accepted that such conduct is almost certainly bad faith. So her point is that it would be bad faith, but it's not so limited. It's important you understand that the Commission was trying to say it's only that, not that it's not included. And just as an aside, consistent with what we see Advocate General Tancher say in our case about the travaux préparatoires, and in particular the replacement of the explicit requirement to have a bona fide intention to use a mark in the earlier draft of the regulation with simply the bad faith provision. My friend says that shows an intention to go back on what had been accepted earlier and to exclude it. Advocate General Tanchev says, and for my Lord's note, I'm not going to turn it up now, this is paragraphs 115 to 117 on page 466 to 467, that the intention was to broaden the scope of the provision, i.e. to still include it, but that it was not going to be so limited. Same view Advocate General Sharpston is expressing here. Now, can I pick things up in the judgment, which is the next, well, if my lords don't have tabs, you just move on to page 2497. And the court's response to the questions it was asked began at para 34 on 2497. Para 36 highlights the situation before the court in that case was where at the time of the application several producers were using on the market identical or similar signs. So it highlights the point that was part of the picture I flagged up to my lords earlier. Paragraph 37 gives a perhaps not unsurprising response that it will actually depend upon an overall assessment, the answer to whether there's bad faith, taking account of all relevant factors. And then the judgment moved on to consider specific factors that had been drawn attention to in that case. The knowledge of a third party's activities is addressed first. That's the point at para 40 on page 2498. And the point is that the knowledge of a third party using an identical or similar mark for an identical or similar product is not itself sufficient to permit the conclusion that it's bad faith. So that means it won't follow necessarily. It doesn't mean it's not relevant. And para 41 explains one needs to consider the applicant's intention, which we see is explained as subjective, although assessed objectively. And para 43 to 45 are important because they address the situation we'd seen earlier was raised in submissions relating to situations where there was no intention to use. And what the court says here is that an intention to prevent a third party from marketing a product may, in certain circumstances, be an element of bad faith. May, doesn't have to be. It goes on in para 44 to explain that in particular the case that when it becomes apparent subsequently that the applicant applied without intending to use it, its sole objective being to prevent a third party from entering the market. So that's where you're applying not intending to use, intending to use as a legal weapon. It's not intended to be accompanied by your own use. Now, paragraph 45 explains in such a case the mark does not fulfil its essential function, namely that of ensuring that the customer or end user can identify the origin of the product. Now, can I just pause there and make a couple of points about what's said through these paragraphs? First, the use of the words sole objective in paragraph 44 is plainly being used because the objective of preventing third parties is also part and parcel of the picture when the trademark owner does intend to use the mark. So when it says sole objective, it's talking there about when you're not actually intending to use it in conjunction, so that your objective of stopping others is going hand in hand with stopping with your own use. It's the kind of point I understand my friend to be making in his printed case where he says a trademark is always a legal weapon. And it's pretty similar to the judge when he says you're going to use it purely as a legal weapon. It's that kind of consideration. Why am I labouring this point? Because I'm labouring it because what I say is important to understand. It is not considering issues such as a broad specification or broad individual terms where there's no commensurate intention to use. Sole objective here is being used to make the distinction between intending to use the mark to prevent and preventing third parties in conjunction with that intention, or solely intending to prevent third parties without the accompanying intention to use. And the reason it's important is because of the way Sir Christopher Floyd took sole intention or objective in the Court of Appeal judgment. We'll come to it, but he's taken it as meaning if you've got any intention to use for some aspect of what you've applied for, this is saying that's not good enough, that's not bad faith. It's not what they're talking about in my submission. They're talking about the point that I've just been on, just using it to stop people rather than accompanying it with the use. So that's important. And it is clearly in my submission also saying this, it will be bad faith where an applicant does this, intending to enforce the right but not use it.
The particular application here was, I understand the point of principle that you're emphasising, but the particular application here was to interfere with, or potentially interfere with, the use, an established use to some extent, by a third party of a particular shape of chocolate confectionery, in circumstances where that third party had itself acquired some rights as a result of that use.
And also,
it's a very fact.
it's very fact specific, and also
it is fact specific. And also, the point of principle that you emphasise.
That obviously the facts of their case were not that Lynn didn't intend to use it. So, in a sense, it's obiter in that it's not directly on point, but it had been that situation had been raised by the submission the Commission had made, and that's why I took you to that earlier submission. So they were debating that as how it fitted into the picture, but it wasn't a case of non-use at all. So I don't want my lords to miss that either. It's not just that it was fact-specific about the other people. It wasn't a case of potential non-use, but they were considering it because of the submission that had been made by the Commission as to it being limited to that situation. They went on to consider other factors from paragraph 46 onwards, and I want to try and cut this short because I'm taking too long. Can I go to 51 to 52? Because that's the other key point about this. So paragraphs 51 to 52. This is about the fact that you're going from having only protection of your sign under national law, which is narrow, to trademark protection, which was broader in this case. And so what they were considering here was whether or not securing trademark protection, which was broader than that non-trademark protection, was justified because of the reputation enjoyed by the sign. And they say that that might justify it. And so paragraphs 51 to 52 is talking about the factor of the reputation of the applicant and how that reputation may justify seeking broader protection. But it doesn't mean seeking broader protection in the defensive registration sense. It doesn't mean you can apply for everything because you're a famous mark, the kinds of things, the protection you get for infringement. It means, are you justified in saying, I'm not really satisfied with this national law, which is limiting me to identical bunnies. I want trademark registration. And so the broader protection is that the trademark registration is the broader protection. It's not addressing a broader form of trademark protection by registering more broadly. And that's really important because, again, Sir Christopher just took it as meaning if you're a famous mark, you can engage in defensive registrations, in essence. And actually, while we're doing this, can I just make good the errors in the Court of Appeal judgment on Lind? So I'm dealing with the printed case, paragraphs 163 to 172. So pages 141 and 142 of the electronic bundle. There are two separate points, and I've already foreshadowed them, so I can deal with them very quickly. I'm going to deal with them in reverse order because the second one is the one I've just been on. So Christopher relied upon paras 51 and 52 of Lint concerning reputation as applicable to seeking broader protection in that very different sense, in securing trademark protection, not only as regards goods and services upon which you use or intend to use, but a broader class. And you see that in paragraph, first of all, 51 of the judgment where those paragraphs from Lint are identified. So that's on page 236. And the point is referred to in the second half of the next paragraph too. My lords see the reference to having a reputation that deserves broad protection about 2/3 of the way through paragraph 52. And if we move forward to point 12 in paragraph 67, so that's on page 257. This is one of the points that he'd identified as relevant to what he was going to apply. And the crux comes, we see, relied upon in his discussion. So if we go forward to paragraph 106, this is para. So 106, I think it's page 269, the very last sentence. He's deploying the point stating Sky's extensive brand recognition, also a reason. It's the court confirmed in Lint justifying broad protection. We say that's quite wrong. That's not what Lint is talking about. It's not talking about being able to apply for many goods and services. It was talking about having trademark protection instead of the narrower national protection. The other aspect we criticise as regard Lints can also be seen in this paragraph, 106. Higher up, the reference to sole objective, about 5 lines down. And this is where he's basically applying sole objective as meaning it's not met if you actually do intend to use for part of it. He's identified a little higher up, 3 lines into the paragraph, there is an intention to use for at least part of what the registration covers. So there are good and bad reasons according to Sir Christopher. Again, that's just a misapplication of what Lint is about in my submission when it talks about the sole purpose. Lord, I see the time.
Yes.
Is that a convenient moment?
Yes, certainly. We'll adjourn and resume at 2 o'clock.